She went on to deflect away from the allegations in the Wade motion, and she said she's saying why in her talk, public discussion with God, why are they only attacking one in reference to Mr. Wade, and then she goes on to say, God, isn't it them playing the race card when they only question one? Now, if she had been truthful with that congregation, truthful with the community, she would have said, I had a relationship with him. Good, bad, forgive me, whatever. That's what she should have said. But she chose to deflect and say them, the reference to them and the others and they. It's obviously a reference to the motion filed by Ms. Merchant. They choose to go after the black man. And she then goes on, again, deflecting away and deflecting to what I call the third rail in American society, choosing somebody on the other side of being a racist. So-and-so is a racist. They're racist. She was the one playing the race card in a way to try to deflect from her own conduct. She goes on to say in discussions with the Lord, God, is it that some will never see a black man as qualified no matter his achievements? Again, the deflection. What is she saying? The listener is not necessarily in that audience in that church. The listener is at Fulton County. The potential jurors who will come into a courtroom and say whether or not they can fairly judge the evidence or judge the defense in this case. She chose to inject race into the minds of the listeners and virtually everybody in this community, and literally everybody in this country has reviewed and analyzed her speech that she made in a premeditated way. And in bringing in not only the race card, but also in bringing in the religious matter, this is exactly what Hammonds v. State and our Supreme Court talks about, condemning as an inflammatory appeal to the jurors' private religious beliefs. Why would she do that? To deflect. But now, not only is she deflecting, but she is then going forward and, in a way, telling the community, telling the congregation that God is on her side, not on the side of these people. God, she said, and when she's talking, and she's saying, God, pray for their souls. I, meaning God, qualified you. I qualified your imperfect, flawed self. I see you in every hour. Do my work. As though she's telling the folks in her very, very, very implicit way, injecting into the minds of the jurors, God wants me to win this case. God wants me to prosecute this case. And why is he going, and why are these others going after the black man? Well, the answer is very simple. As we said in our brief, we didn't mention Ms. Cross, the white female, or Mr. Floyd, the white male, because there was absolutely no evidence, and is no evidence, of a personal romantic relationship with them in which she obtained these benefits. That's the reason why we did not do that. So she goes forward with her with the deflections. That's exactly what she does when she goes forward. And she talks about a planned interviews time and time again with authors of the book, Find Me the Votes, where she's talking about a case that's going to be tried in this courtroom. It's reprehensible.
So in that specific, instance, setting aside the fact that she was willing to go on the record before a case had even reached the jury, what specific statements from that book do you contend cross the line?
Well, for example, she's saying, she goes on to talk about all the calls that she gets from people calling her racial terms. And all the calls are racist. What she's trying to do, and I think there's a reference in there to MAGA people, whatever. In that, what she's really saying is that those people calling me up and making those claims or those horrible racial slurs to me are really people on their side of the fence. That's what she's doing. And there's no reason, Your Honor, ever for a prosecutor to sit down and go forward with this this kind of interview. She did it in Find the Votes. But then they what really happened here is this hiding of the relationship. Because in hiding the relationship, they have done such a good job. Mr. Wade filed false documents in his divorce case when on May the 23rd, May of 2023, talking about, have you ever had sexual relations with a person during the course of the marriage or including the period of separation? He's still married. He doesn't have a divorce decree, but his answer is none. Then he's asked whether or not, on any occasions, he's entertained or been entertained by someone, a woman, a member of the opposite sex, in this case a woman, from the date of the marriage to the present, talking about place and time and all that. What is the answer? None. Why does he do that? He does that because he doesn't want to tell about the relationship that he has with Miss Willis and the benefits that he has gotten and that he gave to her. That's exact. And what these answers are absolutely reprehensible. That a member of the State Bar of Georgia would file these answers that are inaccurate. What does Miss Wade do? Excuse me, Miss Willis do? Miss Willis, on her financial report, on whether or not she has gotten anything of $100 or more in value from a prohibited source. The court asked earlier about what a threshold might be. Well, for the financial report, it's $100. That's it. She doesn't report any of all of the benefits that she received from Mr. Wade. All the trips, all the entertainment, all the 3 nights in the luxury suite in Aruba. All of that. None of that is here. And they say, oh, well, maybe it all balanced out, even though I can't prove it with the cash. Well, that's like saying, did I give the court a Christmas present? Well, maybe I gave the court a Christmas present, and the court gave me one back. If the court has to fill out a form whether you got a Christmas present from anybody, you say, I got one from Mr. Gillen. You don't say, nah, well, I gave him one back, so it really evens out. They're false reports. And because they're false, what they had to do is they had to say, uh-oh, Ms. Merchant has caught us. And so what we're going to do is we're going to get, in our response, we're going to get Mr. Wade to file a false declaration, which he does. His declaration in this case is false. And the evidence showing that that is false as it relates to the timing, and the court asked earlier, why does it matter, if the relationship was before or after November 1, 2021? The answer is they think it's important, and frankly, I do too. Because when she's hiring somebody and she's not telling the people who are going to be paying the tab up to $700,000, hey, I just hired my boyfriend who's taking me on a trip to the Caribbean and taking me down to Aruba and taking me to California. Hope you don't mind. No disclosure whatsoever. And the money flows off. But because they got caught, they then commit what I think is an additional component of forensic misconduct, and that is fraud on this court. When they filed that affidavit, and now it's been proven, I think, beyond virtually any doubt that the relationship occurred prior to November 1, 2021, and the benefits that were there, and we don't have to run around. And I love we've got all the records showing from Mr. Wade about the payment for these trips, for the cruises, for the flights, all this stuff. What's the only way, as they sat around and met together before they testified and came up with their story, what's the only way that they can save themselves? Pay no attention to the records. Pay no attention to the airlines and to the flights and the vacations and the cruises. I paid him back in cash. Show us your receipts. Where did you take cash out of the bank? Ever? Oh, I don't have any. Well, show us the deposits that he had. Well, never. We don't have any. What we have here is a fraud on this court, which has been shown, I think, overwhelmingly by the evidence and overwhelmingly through not only the testimony of Yurdi, the testimony of the emails and the text from from Mr. Bradley to Ms. Merchant, as well as all the documents that they had no answer to other than the just trust me, I gave him money, it evaporated, I don't know where it came from, and he doesn't know what he did with it. Just please trust us and believe us, because it's our only way out of the trap that they set for themselves. These people, sadly, and I hate to say, I was a former, as the court knows, I was a prosecutor for about 3.5 million years, it seems, in the federal building, and I was an assistant DA beforehand. Prosecutors don't act like this. Lawyers don't act like this. These people, Your Honor, is a systematic misconduct, and they need to go. Thank you.
Your Honor, I'm going to cover a few factual details without overly rehashing what has already been said. During the pendency of this investigation in this case, Mr. Wade and Ms. Willis basically lived Robin Leach's lifestyle of the rich and famous. And they did this riding on the backs of the defendants in this case, funded by the taxpayers of Fulton County and the state of Georgia, with the money that was paid to Mr. Wade through the contract that Ms. Willis got him. That money flow, that is the personal interest that you asked about. She was personally benefiting from the position, from the job, from the scope of the investigation, from the scope of the indictment, and how they conducted it. And we know this, we know from the records that have been submitted before the court that Mr. Wade paid at least $17,095 towards this relationship. That does not even include the various dinners, the day trips that both Wade and Willis admitted to. So that number is likely even higher. We know from the documents that Ms. Willis only paid $1,394 for an airline ticket. We know from Ms. Yurdy, who was pretty much uncontested, there was no evidence presented by the state disputing her time frame, that relationship started in 2019. She saw them kissing, she saw them hugging. Now, whether or not they had sex before January of 2022, I do not know. They admitted sometime in early 2022, and I found it curious that they both, Wade and Willis, just went straight to the sex. So maybe that's when they started having sex. I do not know. But the relationship predated that. And their combined and overly suggestive focus on that is a red herring to this court and to the defense, that that's what they want you to focus on. They want you to ignore all the evidence that the relationship predated that. The relationship started in 2019. The relationship continued through 2020. The relationship continued through 2021. Looking at the cell phone communications, just in the first 11 months of 2021, over 2,000 calls, almost 9,800 texts. You know, I don't even think love-struck teenagers communicate that much. The November 29th and November 30th escapade, phone call from Ms. Willis, between Ms. Willis and Mr. Wade, 11:32 that night. Shortly after midnight, the phone starts traveling down from where Mr. Wade lives and ends up where Ms. Willis is staying, and he's there until roughly 4:55 a.m. None of the excuses, none of the explanations that Mr. Wade gave go into the Porsche experience, go into dinner, go into the airport. None of that explains that. I'm pretty sure the Porsche experience isn't open in the middle of the night. I'm pretty sure that there weren't any restaurants that he drove 30 to 45 minutes to go eat at in the middle of the night right after he talked to Ms. Willis. Teenagers have a name for those kind of calls and those kind of escapades. I won't go into it. But the documentary evidence, the objective evidence, undercuts everything that both Wade and Willis said. When you look at Ms. Yurdy, again, she unequivocally said that relationship began in 2019. She saw physical evidence of a romantic relationship. Mr. Bradley, in the text messages, which are substantive evidence, said that that relationship began in 2019. Again, his January, temporary amnesia that somehow was triggered temporarily after Gabe Banks called him, we can question that. But we do have statements from him that specifically said that relationship predated Mr. Wade's appointment by Ms. Willis. You asked, well, in Mr. Wade, you asked what the materiality would be. How much is enough? Well, clearly 17,000 is enough. But Fulton County has told Mrs. Willis what the materiality is. It's $100 in a year. She twice signed declarations, certifications that she did not receive any gifts. And even under her strained explanation, there were monies, there were gifts, there were dinners, there were excess contributions flowing her way that exceeded $100. Her explanation, well, I just paid it in cash. That just does not stand to reason. It does not hold up to the light of truth. Anyone that has ever been in a money laundering trial, a forfeiture trial, if that's the explanation we give the state, they laugh. Oh, I just gave cash. I have no records for it. I have no source for it. The only thing that she could say that was a source for the money, because at times she said she was down to $500 to $1,000. The only explanation she had is, well, sometimes I go to Publix and I may get an extra $50. That shows up on your debit card or your credit card. Did they bring those records in? No. Did they bring her bank accounts in? No. Did they bring any documentary evidence in? No, they did not. And why is that important, Judge? Yes, the burden is ours. But under OCGA 24-14-22, if a party has evidence in such party's power and within such party's reach, by which he or she may repel a claim, and they had that power, Ms. Willis had that power, Mr. Wade had that power, that they can repel the claim that we have made against them, but they admit to produce it, or if they produce weaker evidence, then you, as the fact finder, Judge, it is in your power to disregard that, and a presumption arises that that documentary evidence that is in their possession that they failed to produce supports our claim. And that is something that the state relies on regularly in criminal trials. And that is something that the court should rely on in this case when formulating its factual findings. And we know that both Mr. Wade and Ms. Willis have some difficulty expressing the truth when it comes to their relationship in these cases. We know Mr. Wade lied in his interrogatories multiple times. We know Ms. Willis falsely certified that she hadn't received any gifts from anybody. And Mr. Wade clearly was a prohibited source. He was someone doing business with Fulton County. Anything over $100 in a year, she had to put down, and she put zero. And it defies imagination that she could somehow forget about all these trips, all these dinners, all these day trips, and not put that money down. You had asked, I think it was Mr. Gillen, did she say in that church speech or anywhere else that the defendants were guilty? And I think she did in that church speech. She said in that church speech, and she was talking about a conversation that she apparently had with God, talking about herself. She said, this leader has a trial conviction rate of 95%. She said, the trial team this leader put together has a conviction rate of 95%. I do not see how anyone, and I think that was purposefully intended by Ms. Willis, I do not see how anyone can listen to those two statements and not take that Ms. Willis is telling everyone in that church and everyone that's going to hear that in the media afterwards that these defendants are guilty. That is what she was saying. She is a prosecutor. she's familiar with the U.S. v. Berger. Every single attorney that's ever been a prosecutor is familiar with the dictates of that U.S. Supreme Court case. That is a foul blow. That is improper, and she violated pretty much every tenet a prosecutor must abide by to seek truth and justice in a particular case.
It can be any conflict that impairs your independent professional judgment, and you see that in McLaughlin v. Payne. The court asked what was a personal interest for purposes of disqualification. It's anything that impairs professional judgment. That's reflected in the ABA standards that were quoted by Mr. Merchant, which list the prosecutor's personal, political, financial, professional, business, property, or other interests or relationships. And that's really embedded in the prosecutor's oath to act impartially. And the earlier disqualification order by Judge McBurney was based on political interests, not financial. What my colleagues have described as forensic misconduct is also cognizable as a conflict of interest based on that footnote in the Williams case. The root of all of the problems that we see in this court right now is a conflict of interest arising from their individual personal interests in perpetuating and concealing their relationship. That's the original sin from which all of the other problems flow. There are 6 different actual conflicts of interest in this case, any one of which warrants disqualification, but collectively, practically compelling. First, the financial conflict that's already been covered. Second, the personal ambition, political ambition. Third, there's a dovetailed or complementary pattern of deceit and concealment of the relationship and the money. Fourth, the speech at the church. Fifth, the motion for protective order that the DA filed in Mr. Wade's divorce case. Sixth, the way the state has conducted the defense of this motion to disqualify, especially the hearing. On the financial piece, the court asked for a limiting principle and asked about materiality. The limiting principle is whatever impairs the independent professional judgment of the lawyer. That is applied routinely. We have a county code section that flatly prohibits gifts from contractors, period. We have, by analogy, the federal bribery statute, which has a threshold of $5,000, 18 U.S.C. 666. The court asked about burdens and inferences. The court can draw a negative inference from the state's failure to produce evidence to support the invisible magic cash balancing theory based on State v. Thomas, 311 Georgia 407, particularly footnote 19. As to the timing question that the court asked about, there were 2 contracts for Mr. Wade executed after they acknowledged the relationship began, each one of them afflicted or conflicted under county and common law. The second conflict is her political ambition, for which he was previously chastised by Judge McBurney, and that's also present in this book. The inside flap of this book says that they were given, quote, exclusive access to thousands of secret documents, emails, text messages, and audio recordings. The court has twice denied defense motions to unseal special purpose grand jury materials. She helped herself to get the glory of this book. I introduced certified copies of a number of county code sections. I'm not going to walk through those, but I'll tell you why they matter. The stack of law from the state constitution down to the county ordinances imposes a regime on the DA under which she has 3 obligations. She has to go to the county commission to get approval to pay him like she did. She cannot accept gifts from a prohibited source. She has to disclose the gifts that she received. She evaded all of those requirements. Section 2-69 of the County Code prohibits gifts from prohibited sources, which he was. There's no boyfriend exception. The disclosure forms, the evidence is sufficient for you to find that her disclosure form for 2022 is false and that it is a false writing. That's an actual conflict of interest between her duty, legal duty of disclosure, her legal duty of candor as a prosecutor, and her private and personal interests in concealing the relationship, concealing the gifts, and keeping the gravy train rolling for as long as possible. His part in the pattern of concealment is the story you see in many divorce cases. The husband is hiding things from his wife. How much money he's making, the other woman, and what he's spending on the other woman. And he got on that stand, lied in his interrogatories, and then he got on the stand and he lied about lying in the interrogatories. And the lawyers for the DA's office, they just sat there and let him do it. They did nothing to correct obviously perjured testimony. In and of itself, that warrants disqualification of every one of them. The reason they lied and covered it up was to avoid the trouble they're in right now. That served their personal interests to the detriment of their public duties as prosecutors. The speech at the church, I want to focus on why she did that. Mr. Gillen talked about that. She did it to deflect attention from her own misconduct and that of Mr. Wade. She violated her public duty as a prosecutor to serve her personal interests and the personal interests of her boyfriend. That is a disqualifying conflict between her personal interests and her public duty that is actual, operational, and materialized, and it rests on undisputed facts. The next thing that she did that was a disqualifying conflict of interest was the emergency motion for protective order that she filed in the divorce. I filed a certified copy of that as Exhibit 37. She sought a protective order under the Apex Doctrine on the grounds that she's the DA. And the whole filing is expressly predicated on her status as DA. In fact, she never lets you forget it. She says it 27 times in 12 pages. In that filing, speaking as DA, she said, the circumstances, quote, suggest that defendant Joycelyn Wade is using the legal process to harass and embarrass District Attorney Willis, and in doing so is obstructing and interfering with an ongoing criminal investigation. In the prayer for relief on page 11, she asked for 6 months to, quote, complete a review of the filings in the instant case, investigate and depose relevant witnesses with regard to the interference and obstruction this motion contends. There's no sugarcoating it. That's a clear violation of Rule of Professional Conduct 3.4H, which prohibits lawyers from making threats of criminal prosecution to gain advantage in a civil case. She abused her power. She abused her position to threaten her boyfriend's wife with criminal prosecution to gain advantage for herself and her boyfriend in her boyfriend's divorce. She violated her public duties not to make that kind of a threat in order to serve her private personal interests and those of Mr. Wade. Another actual operational conflict. The last category is the conduct of the defense of this hearing. There were a lot of objections made based on attorney-client privilege during Mr. Bradley's testimony. Most of those objections were made by the state. But the privilege being asserted does not belong to the state. It belongs to Mr. Wade. That shows that the DA's office is serving the personal interests of the DA and Mr. Wade in carrying out further concealment and cover-up of their relationship, and not the cause of justice they are sworn to serve. That is a conflict of interest. It's a continuation of
submitted to the court in which defense counsel claimed the evidence would show. And I would strongly bring to the court's attention that the claims that were made were material misrepresentations. And what I will say to the court, and why I say that to the court, is because the representations that were made by counsel was that Miss Daisha Young, Miss Sonia Allen, Mr. Dexter Bonds, Investigator Hill, Investigator Green, Investigator Ricks, all of these people would be called, and Mr. Bradley would be able to impeach their knowledge by saying that he specifically in his presence or to him said that Miss Willis and Mr. Wade were in a romantic relationship, and that Miss Willis and Mr. Wade were cohabitating, that they all knew that. And I would submit to the court, we didn't hear from any of those individuals. Mr. Bradley impeached no one. And I say no one because he did not impeach Mr. Wade. In order to properly impeach a witness, you have to confront the witness with the specific statements. Mr. Wade, and you can look back at the YouTube of the entire hearings of the last couple days, Mr. Wade wasn't once confronted with a statement that he claimed or said, or that is claimed that he said to Mr. Bradley. The way you properly impeach somebody, you have to confront the witness. Here would be Mr. Wade, and once he makes a statement that you believe to be inconsistent, and you have a witness who can prove that inconsistency, that's when you call that witness. And when Mr. Wade was on the stand, not once was he asked, did you tell Mr. Bradley this in a confidential conversation in your conference room that was not covered under attorney-client privilege? That was not asked. The specifics of that conversation was not asked. So any testimony that Mr. Bradley testified to is impermissible. It is improper impeachment because they did not confront Mr. Wade with it. So that's where the state would begin with the comments that Mr. Merchant made about me referencing his wife as lying. I never called Ms. Merchant a liar. I never used those words. I don't know why she made the material misrepresentations. It could be because Mr. Bradley lied to her. I don't know the reason. So, but I can submit to the court that those were material misrepresentations that were made to this court on the day a few Mondays ago, as everyone was arguing the motions to quash certain subpoenas. I'd also bring to the court's attention that during that motion to quash subpoenas, certain subpoenas, Ms. Yurdy's attorney appeared, Mr. Partridge, and he made very clear on that Zoom that Ms. Yurdy had absolutely no knowledge of a romantic relationship and absolutely no knowledge of cohabitation. Those were the specific references that he made. So what I would submit to the court is those are considered adoptive admissions that his client has made based on the statements he made because of the representations she made to him. So, and I know that sounds convoluted, but what I would say to the court is Ms. Yurdy told Mr. Partridge, because Mr. Partridge told the court that she had absolutely no information about a romantic relationship, and she had absolutely no information as in regards to.
So, but wait, are you making an argument I should make inferences based? Now, these would be attorney-client privileges or communications then. She's communicating with Mr. Partridge about what her upcoming testimony is. That's why she's hired him. And you're telling me I should infer things based on her communications to him?
Absolutely, because they're not attorney-client communications anymore when he discloses them to the court and everybody else as they watch the Zoom and attend the hearing. The difference is there was no request to go in camera. There was no request to go or to have a private conversation with you as was done with Mr. Bradley. That would have been the proper procedure. So, yes, I'm asking you to infer that 100%. I'm asking you to infer that her testimony was at best inconsistent.
Hi, folks. We're back.
Yurdy, when she testified, was vague, very little description. When asked in a very leading manner, is it true or do you know that Miss Willis and Mr. Wade were in a relationship from 2019 into the time you were you were forced to resign from the district attorney's office in March of 2022? She said yes. And then further, when pressed by Mr. Sadow, he talks about why she believed they were in a relationship. And what was interesting from Ms. Yurdy's testimony, that they were pretty close friends up until she left the DA's office, that she asserted to the court that on a yearly basis, Ms. Willis said, I'm in a relationship with Mr. Wade in 2019. Oh, by the way, I want to tell you again in 2020, because we're in a new year, I'm still in a relationship with Mr. Wade. And again, in 2021, the assertion is Ms. Willis then went back to Ms. Yurdy and confirmed, hey, I just want to reconfirm me and Mr. Wade are still in a relationship. It's absurd. It's absolutely absurd. More importantly, when Mr. Sadow asked her about why she believed that they were in a romantic relationship based on her own observations, she said something. He actually asked her, did you see him kissing or hugging? She said yes, but there was no description or qualification about when it occurred, what she actually saw, was it a kiss on the cheek, things of that nature. So I would ask you to frame her testimony from that standpoint when you're addressing her credibility, as the court is going to do with each and every witness that you heard during the testimony of all the witnesses during the hearing. I'm going to see if my screen will share. Now, I want to talk a little bit about the standard and the burden here in this instance as it relates to defense counsel and the claims that they have made in the motion to disqualify. And as I was doing a whole lot of research, I came upon this law review article from Cornell scholarship reading or publication, and they made very clear that courts have been relatively reluctant to exercise their power to disqualify prosecutors for any reason. And that goes along with the standard. What the state would submit to the court is that the defense has to show an actual conflict. And in this instance, they have to show the actual conflict would be that Ms. Willis received a financial benefit or gain and got it based upon the outcome of the case. It doesn't make any sense. It makes absolutely no sense. And during the 3 days of the extensive testimony of all of the witnesses and the prolonged examinations of the witnesses by multiple defense counsel, they still got nowhere. We're in the same position we were in on Monday. The same assertions that were made on Monday have no answers today as we're before Your Honor. They were not able to provide any evidence as to, or to the contrary, of Ms. Willis and Ms. Wade's assertions of when their relationship began. There's absolutely no evidence that contradicts that the relationship did not begin later than or around March of 2022, Your Honor. I'd further submit to the court, because of this failure, that their assertion or their request that, one, the indictment be dismissed. There's absolutely no evidence that the defendants in this case, their due process rights, have been harmed in absolutely any way. There was zero evidence. Not a single shred of evidence was produced through any of the exhibits or the witness testimony showing how their constitutional rights, their due process rights, were at all affected by the relationship that began in March of 2022 with Ms. Willis and Mr. Wade. And because of that, the motion to disqualify should be denied. And Ms. Willis as the district attorney of Fulton County and Mr. Wade as the special prosecutor assigned to this case should be allowed to remain on this case and continue to prosecute the case to the end, Your Honor, until the trial is set by the court and is to begin. Now, the issues, obviously, you've heard a lot from defense counsel as to what the issues are for you to, I guess, determine. And here it would be the state's contention is that you must find that there's an actual conflict if you were or are to come to the conclusion that you should disqualify Ms. Willis and the district attorney's office. And looking at what
I think you're talking about, is this Ventura?
it's McGlynn v. State, McGlynn v. State, 342 Georgia Appeal 170. It's a 2017 case. In that case, as it talks about the standard of proof that the defense, or the burden that the defense must show and go to show an actual conflict, is they say it's a high standard of proof, which is definitely not a preponderance of the evidence, which is a much lower burden for any party who's trying to meet that standard of preponderance. But it's clear that what the standard is that is a high standard of proof for both when determining whether there's an actual conflict and when there's forensic misconduct that is found, Your Honor. State, which is 287 Georgia 542, and all of the cases that fall under this, what I would call category, is about a attorney who formerly prosecuted a defendant in, I guess, the same type of case or the same case or similar charges, and that would be why the courts the courts found that disqualification would be necessary because of the relationship that existed between the former client and the now person who's being prosecuted, Your Honor. The next series of slides just goes through what has been addressed as it relates to the standard that is required when dealing with the issue of disqualification, and the state would contend and submit to the court that the defense must show an actual conflict in order to have the district attorney disqualified, and that actual conflict has to be in the form of showing that Ms. Willis, in this instance, received a financial benefit or gain in relation to the outcome of the case. Like many of the cases that involve personal interest, Your Honor, it's all based on a contingency fee, where how much they're paid, or a bonus, for example, is dependent upon the outcome of the case. That's how one is to show that there's a personal interest in the case. We have none of that here. And I would submit to the court, we have absolutely no evidence that Ms. Willis received any financial gain or benefit. The testimony was that Ms. Willis paid all of the money back in cash as related to the trips, and if didn't pay back in cash, it was
all right. Let me explore this one a little bit. Mm-hmm. So, in addition to you're saying it's only an actual conflict, are you also saying that it's only if a financial interest is affecting the final result, the outcome? That's the only one we should be worried about, or is it that the prosecution as a whole is what we should be looking at in terms of a stake? So what I'm thinking of, I'm just going to try and come up with some hypos here. What if ADAs are given a bonus for every motion to suppress they win, $1,000 per Fourth Amendment claim they win? Well, now they've got an incentive, if one of their officers is lying, not to tell you about it, because they want to win that motion to suppress. But maybe that doesn't affect the outcome, because you can win a motion to suppress or lose it, and that doesn't decide whether it's going to be a guilty or not guilty verdict. But doesn't that affect the prosecution of the case, if not the outcome?
Yes, I would definitely agree that would be an instance where disqualification would be necessary and appropriate, because it's a situation that involves a contingency fee, and I would submit to the court that it actually does end up affecting.
It could, based on how important the motion to suppress is, right? But if it's some immaterial, I don't know. But I guess, so you're saying it's maybe not so much just whether it's a guilty or not guilty dismissal, no pros at the end of the day. it is actually the conduct of the prosecution that should be looked at throughout the course of the prosecution.
Correct, as it relates to how it affects the prosecution, which I would submit to the court ultimately is going to affect the end outcome of the case. If you have a contingency fee based on winning, or how, if you win a motion to suppress and if you win, you get, a bonus, as Your Honor referenced. I think that is ultimately going to affect the end outcome of the case, because, as Your Honor just said, if there's an instance where an officer is lying, or where there isn't a good faith to go forward with that motion, the prosecutor would go forward with regardless, because of the contingency fee, which not only affects the prosecution at that point of the proceedings, but ultimately is going to affect the entire case, because if they were to win a motion to suppress, or I guess the motion would be denied and the evidence wasn't suppressed, knowing that they didn't have a good faith basis to go forward affects the ultimate outcome of the case. So I think it's twofold, as Your Honor has referenced. I think it's at that part of the procedure of the proceedings would definitely qualify for a reason necessary to disqualify a prosecuting agency, but ultimately that action during the procedure will lead to the ultimate outcome of the case being or hinging upon a contingency fee like the ones in the cases referenced by counsel and the state that are on the screen.
So getting into the language again, which you just had up there with greater amusements and amusement sales. Greater amusements is one of those. You refer to the appearance of conflict as dicta. Why do you think that's dicta? I think the quote from that one is, it guarantees at least the appearance of a conflict of interest. Why is that dicta? It seems very central to the holding in the case.
Because I don't disagree with Your Honor, but in that case, an actual conflict was found, and the appearance.
They didn't find that.
I would disagree with Your Honor. My reading of the case is that an actual conflict was found, but because of that actual conflict, an appearance of impropriety was seen, and that's the reference, or why the state referenced that case in relation to the argument that an actual conflict is required. In the series of cases, Young, that was referenced by defense counsel, as well as Nichols, these state are both instances where there's a personal interest in the case due to the situation and where at one point they were opposing parties. And of course, there's a personal interest or stake as it relates to prosecuting an opposing party in a civil claim, which are what both of those cases reference, which shows that there's an actual conflict of interest that relates to the personal gain of the specific prosecuting agency.
And what do you make of Nichols' reference to, it's an older case. Sometimes the language can be what we're not accustomed to seeing, but there's, they refer to the metaphor of Caesar's wife, and generally when that's used as a ethical standard, that's something that goes beyond just an actual conflict, right? Isn't the beyond reproach getting more into appearance world?
Is it getting beyond?
No, isn't getting into the appearance aspect of things when we're talking about Caesar's wife.
But I think it goes beyond that based on the language of the holding in that case, where it literally says that the individual had a personal interest in obtaining a fee by forcing a settlement in the civil case and using the criminal case as leverage. So that's not an appearance of impropriety. That is an actual conflict of interest, in which arises because of the individual's personal stake in the end outcome of the case, Your Honor. So that's how I would differentiate, I guess, the representations of defense counsel as it relates to the standard or the burden that must be shown, and why the state would submit to the court, and the most recent ruling out of the Georgia appellate courts that an actual conflict is required to be shown. So I'm going to skip through these series of slides. We've heard all about Whitworth. So I go back to what we referenced earlier, what's been referenced by all parties, that the grounds in which a district attorney can be disqualified is where a conflict of interest is found, and where there's forensic misconduct that is found. Those are the two grounds that are to be, I guess, are within the purview of the court as it relates to the issues here. And again, I go back to the most recent case that was Justice Pinson wrote about, and that there must be, that by failing to disqualify the assistant district attorney absent an actual conflict of interest. I think the language there is very clear, and I think it's very controlling, and I think it's purposeful, I would submit to the court, because an actual conflict of interest is what is required in order for a district attorney to be disqualified, because the cases make very clear, and through the precedent relating to this issue, that a disqualification of a district attorney is the last, for lack of better words, ditch effort that should be exercised as it relates to the court in curing certain conflicts that may arise. I think the case law is very clear that every effort is supposed to be made instead of, or I guess in lieu of, disqualifying the district attorney unless an actual conflict of interest is what's found, Your Honor. And it can't be cured. So what I would reference to the court, as was brought up earlier in Lyons v. State, 271, Georgia, 639, a 1999 case where it talks about a theoretical or speculative conflict will not impugn a conviction, meaning that speculation, conjecture, things of that nature, assumptions are not enough for anything to arise to an actual conflict. And what I would submit to the court as well, that goes to the fact that what it has to be shown is an actual conflict. If it's speculation.
Is there any qualifier there, though, that's in a post-conviction context?
So
we're talking about, competent evidence. We're obviously in a pretrial phase here. I've wondered how much import to give that sentence when we're in a pretrial realm. That's assessing whether to overturn a conviction, and usually that's kind of an entirely different standard where we assess as a totality: was there a fair trial? Is there harmless error? I know there's no harmless error when it comes to disqualifications, but just a thought. If you have any reactions.
Well, I think what Your Honor said is pretty on point in the sense that if it's found that if the trial court either applied the wrong standard or should have disqualified the district attorney, it leads to an automatic reversal, like you said, and it goes back to the trial court. And I think that is very enlightening in the sense that that's only done if an actual conflict is shown, and the fact that it can't just be theoretical, speculative, or assumptions that would lead to the appearance of impropriety, the appearance of a conflict that would lead to
I guess what I'm borrowing kind of from, as we've been doing in the other pretrial motions, special demurrers seem to get different treatment pre-trial and post-trial. Post-trial, they get more of a pass unless you can show some issues, and I'm wondering if that same principle applies here with disqualification.
Well, and
but I don't have the answer to that.
Well, what I would also say, and I don't remember the exact line, but I know there in Judge McBurney's order, he does address some of the concerns as it relates to the standard as it is applied post-conviction versus pre-trial during pre-trial issues. And what I would say to the court is that.
So you're citing that in support? Because I didn't think the state was all that pleased with the analysis he applied.
Well, what I'm citing.
Legal analysis, that is.
Well, I'm citing what you specifically referenced as to the standard that is to be applied pre-trial and post-trial, whether it makes a difference. And what I would say to the court is the answer is no, as it relates to the speculative nature of the allegations or the claims made by defense counsel as it relates to whether a conflict actually exists, Your Honor. What I can't do at the moment is point exactly to the page at the end of the state's argument. I can give you the page number as it relates to Judge McBurney's order.
I think I know what you're talking about, the footnote where he references the appearance standard.
Yes.
All right, I'm
Right.
looking at it.
Further, in Lamb v. State, 267 Georgia 41, on page 42, it's a 1996 case where the court says, nevertheless, the conflict must be palpable and have a substantial basis in fact. A theoretical or speculative conflict will not impugn a conviction which is supported by competent evidence. Now, I understand as it relates to the post-conviction factor or the status of the case being in post-conviction based on Your Honor's earlier inquiry, but I would submit to the court that as it relates to the issue of disqualification, that the standard is the same whether it's post-conviction or pretrial. In Bloomfield v. Bornstein, which is 247 Georgia 406, it's a 1981 case. In that case, it says the appellees have not shown us a case where a per se rule was applied to disqualify an attorney on the basis of an appearance of impropriety alone. The Georgia cases cited by the appellee do not stand for the proposition that a trial judge is authorized in Georgia to disqualify an attorney solely on the basis of an appearance of propriety, which further goes to the state's submission to the court that the standard is that an actual conflict must be shown, and that conflict that arises shows there's a personal stake of the district attorney as it relates to their personal financial gain that's being alleged. So in the case that's been referenced by all parties here today, Whitworth v. State 275 Georgia, Appeal 790, to 2005 case. In that case, it says Whitworth's complaints are largely based on speculation and conjecture. Applying any evidence standard to the record, it is clear that the trial court did not abuse its discretion in denying Whitworth's motion to disqualify Morgan based upon his personal interest in his conviction.
Aren't we past the speculation and conjecture aspect of this, though? I mean, the original and the core of the financial allegation was that there is a relationship and that money has changed hands. There's maybe still an open question of where the ledger stands, but I think it was conceded that that balance could run in one way or in the district attorney's favor. Is that contested?
Yes. What's not contested is that a relationship did develop between
and that purchases were made back and forth. That's the state's position.
That is the state's position, but they were made back and forth. The purchases were made back and forth, either to equal the money that was spent by one party or the other, and if that wasn't done, cash was exchanged in order to equal the costs that were paid by either one of the parties.
Right, but that's a facted issue, whether it was split even or whether it goes a little bit one way or another, or whether it's all the way $10,000 one way or another. That's a fact and issue as a result of the hearing, but it's no longer just the theory that money changed hand is no longer speculation or conjecture.
Well, I agree that money actually changed hands is not speculation and conjecture, but whether that money that changed hands had any financial benefit or gain to the district attorney, that is all speculation and conjecture. I would submit to the court. Absolutely all speculation and conjecture to harass and honestly embarrass the district attorney based on some of the questions that were asked that had absolutely nothing to do with the proceedings that we were here. For example, the lien on her alleged house, that was highly irrelevant, had nothing to do with the proceedings and the exchange of money between the district attorney and Mr. Wade. The point of that line of questioning was to, again, embarrass and harass the district attorney in a way that was very public, and in a way that was to impugn her character as it relates to that line of questioning in front of the court, in front of anyone watching the proceedings as it unfolded. And the language in Whitworth, I would again submit to the court, requires that an actual conflict must be shown, which is why the reference to speculation and conjecture is again a reference, because speculation and conjecture leads to or equals an appearance of impropriety, not necessarily an actual conflict, which I submit to the court is what is required based on the case law. So in State v. Sutherland, which is 190 Georgia Appeal 606, it's a 1989 case, and it says, while the prosecuting officers should see that no unfair advantage is taken of the accused, yet he is not a judicial officer. Those who are required to exercise judicial function in the case are the judge and the jury. The public prosecutor is necessarily a partisan in the case. If we were compelled to proceed with the same circumspection as the judge and jury, there would be an end to the conviction of criminals, which goes to the premise that the appearance of impropriety is to apply to judges, not prosecutors. Because if that standard was to be applied in the manner in which the Sutherland case is referencing, then there would never be a criminal prosecution, because the state is always going to appear biased as it relates to getting justice for the victims or righting the wrong as it relates to the crimes in which the defendant is been indicted or accused of. So I want to move into I guess the evidence that Your Honor saw and heard during the last couple of days, 3 total days of testimony as it relates to the witnesses. You heard from Ms. Yurdy, who the state would contend is a disgruntled former employee. You heard from Terrence Bradley, also someone who is a disgruntled former partner. The text messages in the state's opinion show that he is vengeful. You heard from his own testimony here sitting before the court that all he did was speculate, and any information that he had and garnered and then passed on to Ms. Merchant was mere speculation. I believe he said that over and over again when asked if he had personal knowledge. My recollection is around 15 times he said he had absolutely no personal knowledge of a romantic relationship between the DA in this high profile of a nature, where everybody would be able to watch and learn what she has to say as it unfolds in the courtroom. And I'd further submit to the court there is reference to she left the DA's office in the text message that were submitted in, I believe, Defense Exhibit 39, that it's because she released confidential information in the DA's office, from the DA's office, that led to her firing, that she wasn't.
And I know I'm just because it's more conversational, which I appreciate. I know I might be getting you off script, so I don't want to use up all your time if you need to get through some other things.
Next, Terrence Bradley, and I believe the one thing that the state and defense counsel can agree on, that he was less than honest at times during the proceeding and during his testimony. When pressed or asked by Mr. Sadow why he was fired, he basically chalked it up to a dispute between partners in a business. But when pressed by Ms. Cross, it was clear that that wasn't the reason. And what I would submit to the court, what has been referenced by defense counsel as baffling as to why the state would go into such a topic area. The state, as all counsel has when appearing before the court, has a duty of candor. And when Ms. Cross knew she was going to have to cross Mr. Bradley, she knew he lied. And she had a duty of candor to the court, in the state's opinion, to expose that. More importantly, it goes to his credibility. And the statements that had been represented by defense counsel that he allegedly had made in the past. So it was important to bring that to the court's attention, because when a witness is testifying, the court is assessing their credibility and determined to whether to believe the veracity of the statements made by the witness or not. So that is the most important factor when determining whether somebody is telling the truth or a lie. Furthermore, he reluctantly, when pressed, finally admitted that he paid off the assault victim. Eventually it started with an escrow account and led to he did pay off the victim in that case. He testified over a span of 3 days, and like I referenced to the court, he must have said 15 times he had no personal firsthand knowledge as it relates to the relationship between Ms. Willis and Mr. Wade. More importantly, when pressed by counsel, he could not pinpoint a time in which he knew that the relationship occurred. There were many instances in which he described that very well could have fallen within the time frame that was testified and by both Ms. Willis and Mr. Wade as it relates to the relationship beginning or transitioning into dating in March of 2022 and into the end of the relationship in August or the summer of 2023. And as I referenced to the court, the statements that Mr. Bradley made, the state would contend are inadmissible hearsay as it relates to the statements that he was pressed and asked about what Mr. Wade told him, because Mr. Wade was never confronted with those statements. And in order for impeachment to be proper, he must be confronted with the specific statements that are alleged to have been made in order to impeach him. Again, Mr. Bradley had every motive to lie. I believe the text messages are kind of clear, are very clear as it relates to his disdain towards Mr. Wade, which due to the fact that he was expelled or exiled from a thriving law practice, and it was clear that the practice and Mr. Wade sided with the alleged sexual assault victim, which is clear he assaulted her due to the fact that he paid her off. And as I referenced earlier, Ms. Merchant represented to the court that Mr. Bradley had personal firsthand knowledge basically of it all, of everything, and that he would be able to basically be an impeaching machine. I think Your Honor referenced him as the star witness when you were addressing the claims that were made by Ms. Cross in relations to Ms. Merchant's representations to the court. And what I would submit to the court is that all Mr. Bradley's representations as it relates to whether or when the relationship between Ms. Willis and Mr. Wade began, and whether they cohabitated, because that was a promise that was also made, that he would be able to impeach the investigators as it relates to cohabitation, was mere speculation, gossip, and innuendo. And this is, Your Honor.
The impression I got, and we can correct this while we're all here together, is that Mr. Bradley directly overheard a statement from each of these individuals that they could be impeached with. Ms. Merchant, is that accurate?
Directly overheard. Which ones are we talking about?
Well, essentially, that kind of seemed to be all of them. You had said Allen, Bond, Young, and then the investigators, Hill, Green, and Ricks, could all be directly impeached by statements overheard by Mr. Bradley.
Yes.
In reference to your question, the unequivocal answer was yes. And when Your Honor is looking through the text messages, I would submit to the court that the text messages don't even say or indicate what was represented to the court in relation to the good faith basis for this motion to disqualify as it relates to the testimony of and the ability to impeach witnesses through Mr. Bradley. What's been referenced by all counsel is Mr. Bradley's assertion of absolutely as it relates to whether the relationship existed prior to Mr. Wade's hiring. And the question in itself involves speculation because it asks, do you think it started before she hired him? And he says absolutely. He doesn't say he knows. He doesn't provide any context as to how he knows. And in these text messages and through his testimony with the court, the source of his information was unclear. What I would say to the court as to a lot of things, other than the one conversation that allegedly occurred between Mr. Wade and Mr. Bradley, and I would submit to the court that conversation never occurred. That would be the state's contention. And how do we know that? We know that because that conversation was not confronted, or Mr. Wade was not confronted with that conversation.
All right, welcome back, everyone. We've been following closing arguments in the Fani Willis disqualification case. Let's listen back in.
There was, I guess, an implication that Mr. Floyd only did so due through his preparation with the state and his hearing and seeing news articles and clips related to the testimony that had occurred prior to him. But I would submit to the court that it's telling that information came out through questions that were asked by defense counsel, which gives credibility to the statements that were made. And he further explained as to why he taught his daughter to keep cash in the home as it relates to financial independence and having a safety net. It was further testified that he had multiple safes and that he gave Ms. Willis his first lockbox, or her first lockbox, for situations as she described when she was testifying. And what I want to make clear is during Ms. Willis's testimony, it was pressed about the cash and where she kept it, did it follow her, where she laid her head, and things of that nature, trying to further discredit the practice that she had as it relates to keeping cash in her home and why she had the ability to pay cash to Mr. Wade and other people and for other situations. And what the court should take note of is that there was no evidence that controverted that at all. Where was the evidence that controverted Ms. Willis's claim and practice of keeping cash in her home? There was none. In fact, the only evidence it was substantiated through the testimony of her father, Mr. Floyd. Furthermore, you heard from former Governor Roy Barnes, and his testimony was significant and important because how I would phrase it, Your Honor, is it debunks.
Let me on this point, and I think you might have had a more recent opportunity to review his testimony than I have. You say on the slide that she was the first choice to lead the prosecution. Was that actually his testimony, or was his testimony that he was asked to come aboard? Did he use the words that he was asked to lead?
Yes, it would be that's my recollection, that he was asked to lead the prosecution. He was asked to he was asked to fill the position that Mr. Wade is currently in, which is the lead prosecutor. It was said in that way as well as it relates to the testimony of Mr. Barnes. So I think it would be very clear. My recollection is that he said lead, but what I can submit to the court that I know he also said that he was asked to fill the position that Mr. Wade is currently filling for the state of Georgia, which is the lead prosecutor. At that
time, as special grand jury prosecutor, right?
Yeah, the special, I guess, yeah, as the special prosecutor, lead the investigation, which led to the ultimate prosecution that we're here before Your Honor today. He also indicated that the reason he turned that job down was because it didn't pay enough. He said he had mouths to feed at his law firm, and that he also didn't want to live the rest of his life with bodyguards because he had lived that for the years in which he was the governor of Georgia. Furthermore, he confirmed the qualifications of Mr. Wade, which I still find it quite interesting and confusing as to attacking Mr. Wade's qualifications, in that it's almost as if Mr. Roman's counsel is asking that the state put a prosecutor on the case that she sees to be more qualified to attempt to convict her client. It's an interesting argument, and it's one that it's Makes no sense. Furthermore, if you were to believe the claims and allegations as it relates to Ms. Willis' personal stake in the prosecution, the receiving of financial benefits and gains, then you'd have to believe that she was also dating Roy Barnes, the former governor, and Gabe Banks, in addition to Mr. Wade, if she has this grand plan scheme in order to profit off of the prosecution of this case. Because that's what they're saying. Or they're saying that she telepathically or prophetically was able to know that Mr. Barnes and Mr. Banks would turn down the position so she could then hire Mr. Wade. It's ridiculous. It's absurd, and it's desperate. It's a desperate attempt to remove a prosecutor from a case for absolutely no reason, Your Honor, other than harassment and embarrassment. This slide, and we've been through a lot of the testimony.
And I should be clear there, it was not introduced in evidence that Mr. Banks turned her down, right? How's that part of the record?
Well, I'd ask the court to take judicial notice, as has been asked repeatedly.
Unless the district attorney had testified to that. I don't recall offhand.
I will be frank with the court. I don't recall if Ms. Willis testified to that exact fact, but I know that Mr. Banks represented that to the court during Monday's hearing as it relates to the allegations that were made. I understand Your Honor's position as it relates to that.
I'm just trying to make sure we know exactly what is in the evidence and is not. But regardless, I think your point is made.
I think it's in evidence of the record as it relates to, I guess, the issues that led up to the actual hearing of this case. So I understand Your Honor's position, but it did come out during a proceeding that was prior to the actual hearing. This slide is just a chart showing kind of the testimony of both the district attorney, Ms. Willis, and Mr. Wade, as it relates to how they met, how or when Mr. Wade became the special prosecutor, when their relationship evolved into a romantic one, talking about the trips in which they took after their relationship evolved into one that became romantic, and when it ended. And what, again, I would submit to the court is that those facts were consistent, and the only person who contradicted that when the relationship started was Ms. Yurdy. And what I would bring to the court's attention is that it was represented to the court that Ms. Yurdy was a witness other than Mr. Bradley who could bring to the forefront this issue of cohabitation. And when pressed and when asked about it, Ms. Yurdy had absolutely no information as it relates to this alleged cohabitation. It was false. She said she had no information. She was asked about trips. She said she had no information about the trips. Yet, she's such a good friend that Ms. Willis confirmed each year that Mr. Wade and her continued to be in a relationship 2019, 2020, 2021, until their relationship ended due to her forced resignation and splintering of their friendship, Your Honor. I guess several exhibits obviously were tendered in. Most of them were exhibits that came from the sealed divorce of Mr. Wade and Ms. Jocelyn Wade, contracts for legal services, trip itineraries, and the text messages. And I would specifically reference prior to today, the only text messages that were before Your Honor were defense exhibits 26 and 27, which Bradley had information as it relates to the relationship starting prior to March of 2022, and that's just false. Those text messages do not contain that. It does not pinpoint, just as Mr. Bradley couldn't, when the relationship actually started. And furthermore, you have the testimony and the evidence of the text messages that it was mere speculation. If you, as Your Honor, reviews the full chain of text messages, it is clearly Ms. Merchant and Mr. Bradley going through what I can describe as nothing else other than a mere fishing expedition between the two of them at first, because it's asked about certain members of the DA's office who would have information as it relates just specifically for one, Miss Young. It is asked whether she would have information, and he had no idea. He said he assumed, he was speculating. And that is the same as each person that was subpoenaed in reference in the text messages. All of that was speculation. And you know it was speculation because not a single one of them testified. That's telling. Because if it wasn't mere speculation, if it wasn't mere gossip, and if it wasn't mere conjecture, each one of those people who were subpoenaed would have been called to testify, like District Attorney Willis was, like Mr. Wade was, in order to be confronted and then impeached by Mr. Bradley. As to what Mr. Wade indicated to the court. And when, I guess after Ms. Willis moved into the condo in April of 2021, they appeared 35 times. Now, I want to make clear to the court, both Ms. Willis and Mr. Wade never denied that he had been to that condo before. The specific testimony that was elicited by Ms. Willis and Mr. Wade was that he had never laid his head, was the direct quote, at that condo, which these records don't prove that he laid his head anywhere. If you were to believe the analysis, or if you were to give credence to what the non-expert says as it relates to Mr. Wade's handset in September and November for the 3 to 4 hours that the phone is alleged to have remained, that doesn't disprove anything that was testified by both Mr. Wade and District Attorney Willis. It was that he visited there. The specific hours of their visits was not something that was pursued during the questioning of both of the parties. So what I would also submit to the court is that if you look at the days as it relates to in September and November, the use, the type of information that is used to make the plots for the longitude and latitude of the handset is data records. It's not voice records. It's not SMS or text messages. It's data records. And it is not uncommon for an expert to testify as it relates specifically to AT&T records that actual data record is unreliable as it relates to the location of the handset due to the type of information that it is, that it's data. It's not the voice and the SMS, which I know, Your Honor, as has been referenced, was a prosecutor not only here in this county, but for the federal government, where this kind of information is commonly used. So in the comments that were made by the court, it was clear that you understood and understand the use of cell phone records as it relates to put somebody in an area, and again, not in a specific location. I'd also bring to the court's attention as it relates to the validity of the affidavit and the analysis done by the expert that was hired by Mr. Sadow, is that not once does it reference the fact that AT&T records commonly have duplicate and triplicate entries within the call detail records. That is something that is commonly seen, and that is something that is seen in these records. And that is something that leads to the incorrect number of times that has been alleged that Ms. Willis and Mr. Wade were in communication through text and voicemail. And I'd also submit to the court that that number doesn't prove anything again, doesn't prove that anybody's in a relationship. It proves that they were in communication with each other. And I think Your Honor can use your own life experience as it relates to people you work with or friends that you are close with, and the number of times that you make calls to any of those people. I can submit to the court that I have a friend who I have been friends with for 15 years, and she worked in the office previously with me. And based on our professional relationship and our personal relationship, the friendship that we had and still have, that we talk 30 times a day. So and that doesn't mean we're in a relationship. So the assertion that the number of times that Ms. Willis and Mr. Wade have spoken to each other, whether it's through text message or phone, it has no validity as it relates to them being in a relationship. what I would submit to the court is that what was shown through all of the evidence was that there's been a true cost to Ms. Willis as it relates to her life, that she had additional expenses that she had to endure because of her position, in the sense that she told the court that she had a mortgage, but on top of that mortgage, that in a house she didn't live in anymore, she had to pay for a safe house, that her home was vandalized, and there were racial epithets and sexual bigotry that were spray painted onto her house. The concern of her safety and her life is something that was testified to, and the fact that this job has led to the isolation and separation of her from her family and friends, which was given credence, and the credibility of those statements were provided by her father, Mr. Floyd, that he had only seen his daughter 13 times since all of these instances occurred. The cruel nature of the statements and the falsehoods that, for example, in these text messages that were purposefully leaked to the media as it relates to Ms. Willis's daughter, subjecting her position in school, that she flunked out of college, which isn't true, which in fact she has graduated from an HBCU. But what's been leaked to the media is the fact that she flunked out of school and someone other than her father moved her, which again, the validity of which was never shown. And all the while, Ms. Willis, facing these costs, has been able to continue to do the work unrelated to this case, which is shown in the fact that Atlanta's murder rate and violent crime rates have decreased while she has been in office. What was shown through the testimony of all of the witnesses and through the evidence that Your Honor heard was that there wasn't an actual conflict, that the defense failed to provide any sort of actual conflict in relation to Ms. Wade's, I guess, the relationship that transpired from the relationship between her and Mr. Wade, and that there was absolutely no evidence of a financial benefit that she gained as it relates to the prosecution of this case and the ultimate outcome of the case. The corroboration of all of that is the things that Your Honor is very much aware that she could have, I guess, financially benefited from stretching out the case, for lack of better words, by the special grand jury recommended that 39 individuals be indicted. But through her sifting through the special grand jury's report and all of the evidence with the team that indicted the case, they only went with 19 of the defendants, which had she gone with all 39, based on the defense counsel's assertions, would have given her the opportunity to certainly find these financial gains that are claimed through the allegations of defense counsel. More importantly, why would Ms. Willis repeatedly ask this court to set a trial date as soon as possible if her motive in prosecuting this case was to continue to financially gain, as alleged, from the prosecution of this case? It doesn't line up. It doesn't make sense. And it doesn't make sense for a reason, because it doesn't exist. More importantly, this office has multiple RICO and as well as large-scale cases like this one, and much larger. And they also have, there's a lot of high-profile prosecutions. If Ms. Willis's ultimate goal by hiring Mr. Wade was for her financial benefit, then she would put Mr. Wade on every single one of those cases. So she could certainly revel in the riches and lavish lifestyle that has been referred to by defense counsel, which there's been absolutely no evidence of. The evidence was she stayed at a DoubleTree in Napa, a DoubleTree. I don't know that to be a lavish hotel. Most people, when they go to Napa, if they want to lavishly experience Napa, stay at the Ritz-Carlton, the Four Seasons, things of that nature, not a DoubleTree. So the allegations and assertions that Ms. Willis was living the lifestyle of the rich and the famous is a joke, absolute joke. As it relates to what you heard, and the secondary issue is the forensic misconduct. And for lack of better words, what it has to be shown is that the statements that were made by Ms. Willis related to the prosecution of the case and ultimately the guilt or innocence of the defendants. And we have none of those statements. There's been no evidence. Nothing has been provided to Your Honor as it relates to Ms. Willis's specific statements made about any of the defendants and in relation to the guilt or innocence of any of the defendants. I forget which defense counsel referenced the fact that she said she had a 95% conviction rate. Well, what Ms. Willis's job is to instill confidence in the community as to how well she is doing as it relates to her constitutional duties. And that was exactly what was done when she referenced that she had a 95% conviction rate in the previous year that she was serving as a district attorney. More importantly, it's been the allegations about race and religion being imputed in her speech, and that those comments were directed at the defendants at this table. And if you listen to the speech, those comments are directed at two elected or political officials. I believe it was Marjorie Taylor Greene and Ms. Bridget Thorne, who is a member of the Fulton County Board of Commissioners here. She specifically used their names. I don't know that they, and my knowledge is they're not supposed to be sitting at the table, and I haven't seen them in my work as it relates to this case, Your Honor. So those allegations that Ms. Willis committed forensic misconduct are, again, there's no validity to them. There's no evidence of them as it relates to any of those comments, which this is an issue that Judge McBurney has previously ruled on when these same allegations were alleged as it relates to extrajudicial statements made by Ms. Willis, and it involved a statement that the words fake electors were said by Ms. Willis, and he found there was absolutely no conduct that was impermissible as it relates to forensic misconduct. And I guess to drive home the point, at no point in any of the statements that were made and that are alleged here as it relates to the speech that she made at the church, at no point did she mention the guilt or innocence of any of the defendants. She, again, was merely responding to comments made by Marjorie Taylor Greene and Bridget Thorne, two other political officials, therefore making her comments not even close in the realm of any sort of forensic misconduct. What I find interesting is that defense counsel wants to make these allegations that Ms. Willis committed this forensic misconduct by the statements that she made in her defense as two unrelated, in this case, public officials criticized the job that she was doing. And, I find the hypocrisy interesting in the sense that we've had video proffers released to the media by defense counsel, emails between counsel released to the media by defense counsel, statements have been made by defense counsel in relation to this case. We had the unredacted version of the cell phone records of Mr. Wade released to the media by defense counsel with his private and personal information causing the threat of harm to both Ms. Willis and Mr. Wade to increase. The most recent instance was the text messages that Your Honor hadn't ruled on their admissibility prior to their release, and it was made clear during the hearings that the ability to get those, the full chain, was something that they were unable to do. But they figured a way, and the minute they figured a way, they released it, the information to the media simultaneously with turning it over to the state and the court. For all the reasons obviously stated before Your Honor, that this motion should be denied because the legal requirements that are required in order for the district attorney to be disqualified have not been satisfied. The defendants have failed to raise any issue legally or factually to satisfy the legal standard for disqualification. They must show an actual conflict. They've been unable to show that the prosecution of this case was at all a result of political bias, which has been accused, or accusations have been made, as well as demonstrated that the prosecution of this case was motivated by any means or any way because of malicious prosecution. And they haven't been able to prove that this case was one of selective prosecution for political benefit or gain. All allegations that have been made during the course of different hearings and the procedures as it relates to this case. What I would leave the court with, and how the state started the argument, is that courts have been generally unreceptive, if not hostile, to attempts to disqualify prosecutors based on pervasive and institutional conflicts, which makes clear that the burden, that the standard is very, very high that must be met in order for an elected district attorney to be disqualified. And that burden, that standard has not been met. An actual conflict has not been shown. And more importantly, in conjunction with that, there's been absolutely no evidence that the district attorney has benefited financially at all, but benefited financially in conjunction with any outcome, whether it be now or ultimately as it relates to the prosecution of this case. And because of all those reasons, Your Honor, we would respectfully request you deny defense counsel's motion to disqualify the elected district attorney, Ms. Fani Willis.
All right. Thank you, Mr. Abadi.
Your Honor, I think we have 5 minutes and 44 seconds.
That's what it says. Mr. Cromwell. Okay, handing it over. Understood. Mr. Sadow, all yours.
I'm going to do rebuttal, specific rebuttal. 1, state somehow makes an argument that we should have asked Mr. Wade questions about his relationship and his communications with Mr. Bradley when they objected over and over and over, and Wade's counsel objected over and over and over, claiming that everything that Bradley was told by Wade was attorney-client privilege. Your Honor made determinations thereafter to Bradley. We didn't get the opportunity to call Mr. Wade back to the stand. So to claim that you can't impeach him because you didn't ask him when they objected to us asking him is obviously a false position to take, as disingenuous as it can be. Now, if the court wants to open it up, we'll be more than happy to call Mr. Wade back to the stand. But as the record stands, there could be no confrontation of Mr. Wade when both his counsel and the state are arguing that it shouldn't be done. Second, let's use a little common sense here. Forensic misconduct received about 2 minutes worth of discussion. The rest of it is all on conflict. Forensic misconduct dealing with the way the state wants you to have it is if you don't accuse someone or you don't say that someone's guilty.
Assuming you can impugn someone's character to the degree that constitutes forensic misconduct, why is that?
I'm sorry, say that.
Here. Assuming you can impugn someone's character to the degree that it constitutes forensic misconduct. I think that I guess the state's primary position was that they weren't talking about you at the church.
Right. And if you go listen to it and watch it, it starts off by saying, why does Commissioner Bridget Thorne and so many others, and then it refers to they attack him for being black. They attack him, not anyone else, just they attack the black man. They're not talking about Miss Thorne or Marjorie Taylor Greene. They're talking about us. And you know how everybody knows that? Because not a single story from the media reported anything other than Fani Willis accused the defense and defendants of being racist. Now, here's the common sense part of this. If you follow the state's position on forensic misconduct, Fani Willis could all day long talk about race. She could say the defendants, I'm not saying they're guilty or not guilty, but they're racist. They're racist. They're racist. And according to the state's position on forensic misconduct, that wouldn't be a problem. Obviously, that makes no sense whatsoever. The issue here that we've dealt with on forensic misconduct is not simply the church speech. It's why she did it, how she did it, calculated, and all the other things that we talked about with the testimony of Wade and Willis in this case. Let's go to the relationship issues and the cell phones briefly. No one knew that there was a relationship between Wade and Willis, according to Wade and Willis. Not a soul was ever told that they were dating or that there was an intimate relationship. Ever. They concealed it from all parties. From Daddy. Daddy didn't even know they had a relationship. Suggest that somehow in the beginning of 2021, January to whatever it was into April, that they couldn't have met in Hapeville. They didn't meet anywhere that would allow the public to see them. That's the reason why they were meeting at Yertes, because no one else was ever there. Remember the testimony? Who else was there besides Mr. Wade and Miss Willis? Both of them agreed. No one ever went there except them. They didn't go to where Daddy was in Miss Willis's house because Daddy was there and Daddy would know. No other prosecutors knew. No one knows except who? The one person that knew was Bradley and Yerty. Yerty was the best friend at that time of Miss Willis, and Bradley was the partner of Wade. Now, the only way that the only way that Bradley can walk away from I have very little time, so I'll skip that. Let's go to something. Motive. That's an issue. Whose motive in this case is the strongest? Fani Willis, Nathan Wade. Because if they testify truthfully on every point, what happens if the relationship started before November 1st? They get disqualified. Who has the best motive of anyone to lie? They do. Who has the most at stake to lie? They do. Who wants to stay on this case for whatever the financial reason may be? They do.
And more. Thank you, Mr. Sato. There it is. All right. Thank you, everybody. I think it's been very much made clear by the argument and the made today is that there are several legal issues to sort through, several factual determinations that I have to make. And those aren't ones I can make at this moment. And so I will be taking the time to make sure that I give this case the full consideration it's due. I hope to have an answer for everyone within the next 2 weeks. Until that point, if there are any other issues that come up, counsel can reach out, and we'll have an order posted on the docket. Thank you all. We're off the record.